Number 100, People versus Rebecca Ruiz.
Good afternoon. May it please the court. My name is Andrew Molitor from the Chautauqua County District Attorney's Office for the people of the state of New York. This case is unlike many temporary lawful possession cases that have been before this court. This is not a situation where the defendant fortuitously found a gun and intended to surrender that gun to the authorities, nor is it a case where the defendant came into possession of the gun by disarming an attacker.
Do you think you can have temporary and lawful possession in your home?
Is it possible? It may be possible under a different fact pattern than this case, but I don't think it was possible in this case for a variety of reasons. I think a review of the evidence, a reasonable view of the evidence in this case would show that the defendant had a prior criminal conviction and was not allowed to possess a firearm.
Is constructive possession preserved here?
I believe it is, Your Honor, and if it isn't, I don't think anything is preserved. This case never should have been decided in the appellate division because the defendant asked for temporary lawful possession and we objected and we cited the relevant standard. And the lower court can view all the evidence.
When you objected, you didn't say constructive possession when you objected, but I believe in the post-trial motion you made several statements that could be construed as constructive possession. Let's assume that just for a second. Do we nevertheless have what the appellate division identified as a LaFontaine problem?
Yeah, I don't believe that this is a LaFontaine problem, Your Honor, because when the court is making a decision like it did in Butts, this court, when the court is making a decision as to whether it should give a charge as to a defense, it can view it takes a reasonable view of all the evidence and all the reasonable inferences that flow from that evidence. And so I think the appellate division could have, looked at all the evidence and all the reasonable inferences that flowed therefrom and said, yeah, this clearly there was a constructive possession. She was in constructive possession, and that precludes us from ever getting to the temporary lawful possession defense, and the court did not abuse its discretion. If you think about some of the facts that are cited in defense of what I would say the justification argument, those are also facts that were never raised as part of the argument at the trial level, but they're being used here, I believe, to conflate justification and temporary lawful possession. Beyond that, if we don't even get to temporary lawful, if we don't get there with constructive possession, she is in actual possession of the weapon. And, as I said before, there is no, this is not a situation where she was disarming an attacker or a situation where she fortuitously found the weapon. And then ultimately...
Well, that's what she claims, though, right? That's her testimony. She fortuitously found it.
That's her testimony, yes.
We do have to view the evidence in the light most favorable to the defendant, don't we?
That's true, but it still needs to be reasonable and rational. And I, lay out in my papers all of how all the evidence and the reasonable inferences show that testimony really isn't rational.
Why is it not rational?
Well, Your Honor, I think it's illogical for someone to be under the situation that she describes and to go into the kitchen towards the perceived threat and pull out of a kitchen drawer, just by happenstance, a gun that's fully loaded and ready to go, and not know that gun is there.
Is it possible that, there's a commotion, there's some banging at the door, she runs to the kitchen? Even if I knew I didn't have a gun in the house, I don't think it's beyond the realm of possibility that one could open a kitchen drawer to see if there's something heavy or sharp or something in there that you could use to defend yourself. She just happened to find a gun when she opened it.
I completely agree with you about that, Your Honor. But she wasn't supposed to have guns in her house. And she said, look,
So you're saying she didn't have the right to pick up that gun, having found it?
I'm saying that she knew about it and she didn't have the right to pick up that gun.
Well, so suppose it was actually her ex-husband, Spoons or Waldo, whatever you want to call him, and he had broken down the door. At that point, she opens the drawer, finds the gun. You still think she can't use it? It's temporary, that doesn't meet temporary lawful possession?
Yes.
He's armed, and he fires the shot first and misses?
I understand. I understand the emotional component to what I'm saying, but yes, I don't think she can, or at least it's not lawful for her to do so, because the legislature never intended for justification to be a defense to a possessory crime. And this court in Pons made it clear.
No, I thought you were
never.
going to argue the legislature never intended for her to have the gun in the house to begin with.
That also. That's also the case, Your Honor. That's also the case.
Counsel, could you tell me what happens to the gun? What's in the record about what happens to the gun?
We don't know, per se. Exhibit 6, which was in evidence at the 52nd mark, is when she says, get rid of this, I can't go to jail. And she testifies that she testified that in explaining that 911 call, that it wasn't the gun that she used. She had just dropped the gun and she didn't know what happened to it. She says instead, what she was doing is telling someone to get rid of the gun and the drugs that was on the victim. So we don't know.
How long is it between the shooting and the time the police arrive?
I'm not sure exactly, but it was a very quick time period.
The other part of the charge in this case, besides the legal possession of the gun, is the intent to dispose of it safely as quickly as possible, is it not?
It is, Your Honor.
And it occurs to me here that she said get rid of this, but we don't really know what this is. But even leaving that out of it, I don't see an effort on her part to help the police find the gun. She just said it's over there somewhere. And is there any evidence in this case that you can point to? And I'll ask this question of your adversary. But is there any evidence that you can point to that speaks to an intent to dispose of the gun?
No, Your Honor. None. I don't think there's any at all. In fact, that original 911 call, you can hear the operator saying, "Where's the shooter? Where's the shooter?" And she says, "He ran. He's gone." So I don't think there was ever any intent to safely dispose of that weapon.
Well, given the circumstances, is it possible that, since you've said it's been a short period between in response to Judge Garcia, a short period between the shooting and when the police arrived, that perhaps you didn't have the opportunity to really think that through, having been, she says, right, this is her testimony, fear for her life, shoots through, then she realizes shot someone else, and she's distraught, and just releases the gun. Is it possible that in that moment, perhaps it's not an opportunity to really think coolly about, well, what will I do with this gun?
Well, I would say, Your Honor, that the facts, at least that 911 call points to the exact opposite, which is that she coolly told the 911 operator that it was that the shooter was somebody else, and she's inadvertently caught saying, "Get rid of this, I can't go to jail." So, and then I'll just conclude with, even if there is a legal excuse for possessing the weapon, she uses it in a quintessentially dangerous way, and justification does not mean safe. Here, what she did was very dangerous, and we just can't get around the fact, no one can get around
When
the
you
fact.
say dangerous, not because she killed somebody, but because she shot through a door without knowing who was on the other side?
Yeah, and she says she fired a warning shot through a door from the inside of her house to the outside, where it could have struck someone in another house, someone driving in a car, or someone walking nearby.
Thank you.
Thank you, Your Honor.
Counsel, before I forget, is there any evidence of this record of your client making an effort to safely dispose of the gun as quickly as possible?
John Morrissey on behalf of Ms. Ruiz. The first thing that she does upon leaving the house is she begins to try to render medical aid to Mr. Dumont. So she drops the gun outside and immediately begins trying to help him. She calls 911 and is on the phone with them begging for police to get there.
Is she required to safely dispose of it in order to get the benefit of the charge?
I do not believe so. It's certainly an underlying policy justification of the defense, but I disagree with the idea that it is one of the requirements of the charge. I think this,
Isn't it in the charge? Isn't that specific language in the charge?
or I think I misspoke with charge, with this court's test to determine when the defense applies. And those two requirements are that there be a legal excuse and it not be used in a dangerous manner. If we look at the charge contains almost like a catch-all list of possible elements, and then looking at some of the appellate division case law, we tailor these specific parts of that charge. But I don't believe it is required to immediately dispose of the gun to police. She wants police there. She's telling the police the gun is over there. She drops it. She relinquishes possession very early on into the encounter, as soon as she no longer needs to defend herself. And there's also no evidence that she's trying to hide the
Didn't we
gun.
decide this case already in Williams?
I don't believe we decided this case, or not we, that this court has decided this case in Williams for two reasons. The first, the only issue before this court is dangerous use. That's the only preserved issue, and that's the only issue that was ruled on adversely by the trial court. And Williams 2020, I assume Williams 2020, not 1980, correct?
Yes.
And Williams 2020, the majority explicitly says we're not talking about dangerous use. But even if we set aside those procedural issues, there's a key factual distinction. In Williams 2020, you have possession, imminent threat, and then use. So the possession, the crime, has been completed before there's any legal excuse to pick up the gun. In this case, we have a situation of imminent threat, then picking up the gun exclusively to deal with that threat, and then relinquishing possession as soon as the threat has been erased. So that timing component is a key distinction.
Threat's erased because she shot him and killed him, but why isn't it dangerous use? Since you say that's the preserved question, why isn't it? Why didn't she use it in a dangerous way?
Because at the time, she believed her estranged husband was beating in the door, something he had done before to break in, possibly kill her. She has 4 children in the house, and so she has a need to defend her house, her children, her property from this man. Not only that,
It was a windowless door, was it not? You couldn't see through the door that she shot through, could you?
it is a windowless door, but there was someone banging on the door that's identifying themselves as her estranged husband's and very loud, threatening.
Well,
and-
that may be why she shoots. That's about justification, and the finder of fact agreed there. What about the dangerous use when it comes to the possession of the weapon?
I think when we consider dangerous use, we need to consider how and why Ms. Ruiz used the weapon. And some of the facts that relate to justification are naturally going to relate to dangerous use.
Such as? Which parts of justification are a factor in dangerous use? Because we've opined that there isn't much of a connection between those two.
So the legal doctrines are distinct, but some of the facts that may support justification may also support temporary lawful possession. And I think we see that in the Almodovar case, where we had a situation in which the accused shot someone 4 times, point-blank range in self-defense. And this court said, no justification, but in those circumstances, the accused is entitled to a temporary lawful possession charge. That is after Williams 1980, after the court has taken dangerous, or after the court has announced the dangerousness requirement. So we have a situation where justification and temporary lawful possession are not only not mutually exclusive, but also some of the same facts are going to...
Can I ask you a different dangerous use question? After she used the gun, and you have your argument about, you know, the responsibility of the way she used the gun, she then, apparently by her own testimony, throws it into the yard. Is that a safe use of a gun?
So she drops it in the yard. I think it's important to remember why she's doing that. She is trying, at that point, to save the life of someone. This is a very, very emotional time. I disagree very much with this idea that you could listen to her 911 call or hear her phone calls and think this is a cool situation. She had just believed her estranged husband was going to break in and possibly kill her, so she makes a very difficult decision and then finds out that she just shot the person that she loves. And so she immediately begins trying to give aid, putting possession of the weapon, relinquishing possession.
And you argue that the 911 tape doesn't suggest otherwise.
So in the light most favorable, because we have Ms. Ruiz's testimony about what happened to the gun. She said, I dropped it, I was not telling anyone else to take it. And in the light most favorable, the jury credits that testimony. And to the extent that we have arguments that have been advanced differently, saying, well, there's actually a couple factors that weigh against it, I think those are better for closing arguments than a light most favorable.
If the constructive possession argument is preserved, I'm not saying it is, if it is there a LaFontaine problem?
I certainly think there is. The words constructive possession aren't even mentioned in trial. If we look at the People's Bill of Particulars,
Well, how about post-trial?
I think there's still a LaFontaine issue because we're talking about the trial court denying the instruction. And when it denied the instruction, it's only citing to the dangerous use component. So I think that the LaFontaine issue persists. Now, speaking of dangerous, I think the Williams 1980 case also illustrates...
If this is not dangerous use, what would have been dangerous use?
I think if you...
Shooting through a door when you can't see who's behind it, shooting out into, right, a residential area. If that's not dangerous use, what would have been dangerous use?
So I think there's a fuller way to view Ms. Ruiz's action, that she says, gives a verbal warning before firing, fires a single shot, and it is only after you have a person identifying themselves. She's not guessing that. She's entitled to believe that is Walter Dupre outside the door. He said his name and he's done it before. I think if she had continued to fire, if she had fired multiple shots, that's something that could distinguish or...
What if she fired only once and didn't hit Mr. Dumont, but hit one of the passerbyers?
I think we have a situation in which she tried to mitigate that. She says even though she was firing a warning shot, it was pointed at the door. The passerbys, they're not...
Could you just go, I don't understand how that's a mitigation. You're firing a warning shot at the door of which you believe there's someone standing on the other side of it, and you probably should be charged with knowing that there's a street beyond that where people are passing by. How does that justify her actions?
I think because it shows she's trying to keep the gun directed towards the threat that she's facing. That she's not, if we look at something that happened in...
But she can't see the threat. You're arguing that she thinks her ex-husband or husband is there. And I'm not debating that, but she can't see who's on the other side of the door or where they are. So how does she even know it's a warning shot? How does she not know that it's a kill shot?
I think we have her testimony that it was her intent not to kill the person, and we, in the light most favorable.
I don't doubt that either, but I'm saying, given the circumstances, given the lack of visibility, she has no idea what she's shooting at.
I disagree with the idea that she has no idea what she's shooting at. I appreciate the court's point in that she can't see, but there is a lot of other information available to her about who is on the other side of the door. I don't think it would have been very safe if, you know, she's going to open the door to see who it really is. If she had done that in March, the last time this had happened, she would have been in much greater danger if someone's banging on the door saying, hey, it's spoons, and she says, well, I'm going to go double check that. I think that would be a much more dangerous situation. And I apologize, I see my
Finish
light.
your comment.
And when we have seen this court talking about dangerous, I think we have the quintessential example of Williams 1980, in which the person is spinning the gun on their finger like a cowboy, and it goes off. So something far and away more reckless and unreasonable that put other people's lives at risk, as opposed to taking a single shot because you believed your abusive husband was trying to break down the door again and possibly kill you in front of your children.
But it wasn't him at the door, right? It wasn't the estranged husband.
It was not. It was her current boyfriend, but he had identified himself as Spoons, Walter Dupre, the estranged husband's
He
nickname.
testifies he's identifying himself as my ex-husband at the door.
Yes, and then I think you combine that with the fact that her ex-husband had done pretty much this exact same thing before, that is a very reasonable and fair belief to assume that that person is telling the truth.
Thank you, counsel.
Thank you.